Welcome to the PBM Insider. I am Jim Lodge, an actual PBM insider. Two headline ERISA cases show exactly how PBM contracting can become a fiduciary flashpoint. First, we have Wells Fargo. In Navarro versus Wells Fargo and Company, which was filed in the state of Minnesota, 4 former employees alleged the bank imprudently managed its prescription drug benefits by sticking with the PBM on terms that led to inflated prices and fees. One cited example, the plan allegedly paid over $69,000 for a tube of the cancer drug bexarotene that could be purchased elsewhere for under $4,000 and paid steep administrative fees to the PBM. Plaintiffs said Wells Fargo failed to negotiate better terms, monitor pricing methods, and consider a move to a pass-through structure. So what eventually happened? Well, on March 24th of 2025, the court dismissed the case for lack of Article 3 standing, not because PBM concerns were meritless, but because these particular plaintiffs didn't show concrete personal injury traceable to the plan's PBM decisions. That order underscores a key litigation hurdle. Participants must tie alleged PBM overcharges to their own out-of-pocket harm. Next, we have J.P. Morgan Chase. On March 13, 2025, current and former employees filed Stern versus J.P. Morgan Chase and Company in the Southern District of New York, targeting J.P. Morgan's PBM arrangements with its PBM. The complaint claims the plan paid grossly inflated drug prices and excessive fees, citing dramatic markups. For example, a 30-unit prescription for teriflunomide that could be as low as $26 cash price at retail was allegedly billed to the plan at $6,229. The suit also alleges conflicts, arguing J.P. Morgan protected lucrative business ties in the healthcare sector with its PBM rather than pushing it for lower costs. The case status is currently pending. Across both suits, though, the legal theory is the same. Under ERISA 404A1, plan fiduciaries must act prudently and solely in participants' interests, so they must negotiate PBM contracts, monitor pricing methodologies, be they AWP versus NADAC versus actual acquisition cost, ban spread pricing, capture rebates for the plan, and consider pass-through models. Failure to do so can trigger fiduciary breach and prohibited transaction claims. Even if, as in Wells Fargo, a case can still fail on standing. The practical takeaway for sponsors: document a rigorous PBM RFP and oversight process. Require claim and encounter level data. Audit the pricing, be it MAC for generics, the brand pricing, the specialty pricing, what have you. Prohibit spread pricing. And certainly get away from opaque fees. Keep it as transparent as possible. And align rebates and administrative fees to the plan, not the vendor. The plaintiff's bar is watching these contracts very closely, and courts are starting to draw lines on both substance and standing. More to come. This is the PBM Insider, keeping you informed.